The internet has a way of taking a kernel of truth and turning it into something that spreads like wildfire, often leaving a trail of anxiety in its wake. Lately, a particular warning has been making the rounds in Facebook groups and chain emails. A dire alert that claims the Social Security Administration has implemented a new rule for 2026 that allows them to suspend your benefits if you miss a single email. The headlines are designed to terrify, promising that a simple oversight, a message that lands in the spam folder and gets deleted without a second thought, could be the difference between a check arriving on time and a sudden, unexplained gap in income. It's the kind of story that preys on a very real fear, the fear that the systems we depend on are becoming fragile, automated, and unforgiving. And like most stories that spread with that kind of velocity, it contains a sliver of truth wrapped in a thick layer of distortion. The reality of how the Social Security Administration communicates with beneficiaries and what happens when that communication breaks down is both more reassuring and, in some ways, more complicated than the viral warnings suggest. The actual regulations governing when and why the SSA can suspend benefits are not new for 2026, despite the breathless claims. They are long-standing rules, codified in places like Title 20 of the Code of Federal Regulations, specifically Section 416.1320, which has been on the books for years. That section is quite clear about the circumstances under which suspension is proper. It lists things like a recipient no longer meeting the medical requirements for disability, or having resources that exceed the allowable limits for supplemental security income. But tucked into that regulation is a phrase that likely forms the basis for all the online panic. The section notes that payments can be suspended for administrative reasons, and it gives a specific example. When mail is returned as undeliverable by the Postal Service, and the administration does not have a valid mailing address for a recipient. There it is, the kernel of truth. The government can, in fact, stop your payments if they try to reach you and the message comes back marked "Return to Sender." If they don't know where you live, they can't verify your continuing eligibility, and the law does allow them to pause benefits until they can reestablish contact. But notice what that regulation does not say. It does not say email. It says mail, specifically the kind handled by the Postal Service, the physical letters that arrive in the box at the end of the driveway. The Social Security Administration, for all its modernization efforts, still operates on a paper-based legal framework. Official notifications of overpayments, requests for updated information, notices of continuing disability reviews. All of these critical communications are still sent through the United States Postal Service as the default method. The agency has been expanding its online services for years, encouraging beneficiaries to create My Social Security accounts, where they can view notices electronically and manage their information. But the creation of an online account is optional, and even for those who use them, the legal weight of an electronic notice is a complex area. The idea that the SSA would flip a switch and make email the sole official point of contact, with automated suspensions for non-response, is a fundamental misunderstanding of how a massive federal bureaucracy actually operates. They are bound by laws and regulations that require due process, and due process, in this context, still looks a lot like a piece of paper in an envelope. What is true, and what the viral warnings are clumsily groping toward, is that the SSA has been quietly but steadily pushing for more digital interaction, and that shift does create new responsibilities for beneficiaries. In recent years, the agency has been updating its information collections and seeking approval from the Office of Management and Budget for changes that reflect a more modern, automated approach. For example, in their notices about the Continuing Disability Review Report, they explicitly describe 3 modalities for response: a paper form, a field office interview, and an online system they call the I-454, which provides recipients with a fully electronic platform for submitting information. They are actively building the infrastructure for a more digital relationship. The agency has also been making minor revisions to forms, updating Privacy Act statements, and streamlining processes, all with the goal of making it easier for respondents to use electronic processes. The direction of travel is clear. The SSA wants to move toward a system where more communication happens online, where responses are faster, and where the burden of mailing paper forms is reduced. For a tech-savvy beneficiary, this is a convenience. For someone who barely uses a computer, it's a potential trap. The confusion and the fear stems from the gap between the official communication channels and the informal ones. The SSA is not going to send a critical notice about a benefit suspension to your Gmail address and expect a reply within 48 hours. That is not how this works. But they are increasingly relying on the email addresses associated with your online account to send you alerts that you have a message waiting for you inside the secure portal. This is a crucial distinction. You might get an email that says, "You have a new message from the Social Security Administration." And if you miss that email, if it goes to spam or you delete it without opening it, you might never log in to see the actual notice. And that notice could be a request for information, a notification of a scheduled review, or any other piece of communication that, if ignored, could eventually lead to administrative action, including suspension. The missed email doesn't trigger the suspension. It triggers a missed deadline that triggers a follow-up paper notice that, if also ignored, could trigger the suspension. It's a cascade, not a single point of failure, but the cascade starts with a digital nudge that is easy to overlook. The anxiety around this issue is also fueled by a broader sense that the safety net is becoming harder to navigate. There have been real, substantive changes to the Social Security landscape in recent years, and they color how people interpret new information. The Social Security Fairness Act of 2023, for example, repealed the windfall elimination provision and the government pension offset, sending out over 3 million payments totaling billions of dollars to people whose benefits had been reduced. That was a massive positive change, but it also involved complex retroactivity calculations and required many people who had never filed before to suddenly navigate the application process. At the same time, there are perennial discussions in Washington about the long-term solvency of the trust funds, and the SSA's Office of the Chief Actuary publishes detailed analyses of proposed changes, including options that would alter the cost of living adjustment or expand coverage to new groups of workers. These are serious, high-level policy conversations, but they trickle down into a general public sentiment that the system is in flux, that rules are changing, and that it's easy to fall through the cracks. For the average senior, the practical advice is actually quite simple and far less alarming than the viral posts suggest. First, make sure the Social Security Administration has your correct mailing address. That is, and will remain for the foreseeable future, the most important point of contact. If you move, tell them immediately. Second, if you have an email address on file with them, either through your online account or because you've corresponded with them digitally, check it regularly. Not just the inbox, but the spam folder too, because automated messages from government agencies have a nasty habit of landing in spam. Third, if you are able, create a My Social Security account at ssa.gov. This allows you to see all your notices in one place, to verify your earnings record, and to manage your direct deposit information. It gives you a window into what the agency sees, which is the best defense against administrative surprises. And fourth, if you receive a communication that seems confusing or threatening, do not ignore it. Call the SSA at their toll-free number, or better yet, visit a local field office and speak to a person. The bureaucracy can be slow and frustrating, but it is not a monolithically automated machine that cuts people off without a human ever looking at the case. The warning about benefits being suspended for a missed email is, in its purest form, a myth. But it's a myth that points to a real shift in how government interacts with citizens. The analog world of paper notices and postmarks is slowly giving way to a digital world of portals and alerts. For a generation that came of age in that analog world, the transition is fraught with potential for missteps. The underlying fear is not that the SSA is going to become cruelly efficient overnight, but that the familiar rules of engagement are changing, and that the penalty for not keeping up could be the sudden disappearance of the check that pays for groceries, for medicine, for keeping the lights on. The truth is less dramatic, but demands the same vigilance. The system is modernizing, and with modernization comes a new set of responsibilities for the people it serves. Staying informed, keeping your contact information current, And understanding that a notification in your inbox might be the first step in an important process is the real lesson. The checks are not going to stop because you missed a single email, but they could stop if you missed the conversation that email was trying to start.